Sir, now I'm giving the session from starting from Prachi Pratap ma'am. So ma'am, now you can elaborate on this topic ma'am, and we are very much delighted that we will listen you with each point, because this is one of the important topic, and it is a very renowned judgment, Kesavananda Bharti. So over to you ma'am.
Thank you so much, sir. Thank you, Rajesh sir, for having me. Thank you, Dr. Akhil. And thank you, Sanjay sir, and thank you, Shashi sir, for giving me the opportunity to speak. And I would make sure that I finish it fast so that I have the opportunity to listen to both of you, from whom we all have so much to learn today. So I'll just start screen sharing with your permission, sir. So is it visible, Rajesh sir?
Yes, ma'am, it is visible.
Okay, sir. So let's start with the basic topic that we are doing today is revisiting Kesavananda Bharti case. And so let's look at why is there a need for amendment. The socio-cultural evolution calls for laws which are dynamic. Society, economy, and political scenario are constantly changing and evolving, as we know in anthropology and history, that constantly laws adopt themselves based upon the needs of the citizens, based upon the needs of the economy and the society at large. The soon to retire Justice Stephen Breyer had said that Constitution is a living document that allows courts to give it a more dynamic reading when it is not clear what the framers had in mind. So let's also look at, he talks about the interpretation. First point is always how we interpret the Constitution in order to ensure that the basic premise stays the same, which is the fiber of any democracy. So what the procedures for this? Under this method, the letter of law does not change, but its meaning and its import changes. This method includes amendments by the courts, by interpretation, by legislation, by filling gaps, or supplementing the Constitution, by changing a well-established convention and constitutional usages. And it is very important to know why we need to change the well-established conventions, because we also often see that there are societal norms that might have been useful 100 years ago, but over a period of time, they are no longer needed. The next step is perceptible or formal process. Under this process, the method, the text of the law, that is the written provisions of the Constitution, is amended by way of addition, variation, or even repeal. So let's look at the case of State of Madras versus Champakam Dorai Rajan. This 1951 is the landmark decision of Supreme Court, which led to the first amendment of the Constitution. Now, in this, we notice that this was the first major judgment regarding, sorry, I'm also not able to see my screen. One moment, I need to, yeah, now I'm able to see. So this was the first major judgment regarding reservation in India. Now, this judgment was anti-reservation, and let's have a brief look at it. So in this case, what happened was that the Supreme Court ruling that Supreme Court upheld the Madras High Court judgment, which in turn had struck down the GO that had provided for reservation, which was based upon caste of a person. So this was the first time a caste-based reservation issue had come to the knowledge. The Apex Court held that communal GO was inconsistent with the provisions of Article 29, subsection 2 in Part 3 of the Constitution, and it was void under Article 13. So the Constitution's First Amendment Act, 1951. This was the most important change carried out by this amendment, and it was the creation of the 9th schedule of the Indian Constitution to remove practical difficulties created by court decisions on acquisition of zamindari land, the scope of fundamental right of the freedom of speech, trade, and state monopoly. So we look at that this First Amendment created a more egalitarian society. That was the outlook, to create more equality to bring forth the concept of of democracy, as we know that it was not the same when we got freedom from the British rule. Now let's look at Shankari Prasad versus Union of India, AIR 1951. The argument against the validity of the First Amendment was that Article 13 prohibits enactment of law infringing or abrogating the fundamental rights. The court held that the terms of Article 368 were perfectly general and empower the Parliament to amend the Constitution without any exception. The fundamental rights are not excluded nor immunized from the process of constitutional amendment under Article 368. Now let's see what this led to. The Constitution Fourth Amendment. The Fourth Constitutional Amendment Act amended Article 31 and Article 31A. As a result, an individual could challenge the executive order in the court of law regarding the adequacy of the quantum of compensation paid for the compulsory acquisition of property for public purpose. And this is extremely important even today, when we are looking at matters where quantum of compensation is a very important key point in many laws and cases related to land acquisition. So in State of Bengal versus Bela Banerjee in 1954, the Supreme Court held that the compensation payable for property compulsory acquired under Article 31 is the just equivalent of what the owner has been deprived of, or about the time of acquisition of property, and the issue regarding payable compensation is justiciable. So it is very important to know this minor point of justiciable at the time of compensation. So let's look at the 17th Amendment. I'm skipping the amendments in between because my seniors are going to elaborate more. So this secured the constitutional validity of acquisition of estates and palace land acquisition, and put place land acquisition laws in Schedule 9 of the Constitution. Now, very important to know that this is the point where it was inserted in the Constitution schedule. So let's look at Sanjay Singh's case, AIR 1965. The validity of Constitution's 17th Amendment, Act 1964, was called in question. By this amendment, a number of statutes affecting property rights were placed in the 9th schedule and were immunized from court's review. So see that there was a immunity granted at this point. The court observed that the genesis of the amendment made by adding Articles 31A and 31B is to assist the state legislatures to give effect to the economic policy to bring about much needed agrarian reforms. Supreme Court ruled by a majority of 3:2 that the pith and substance of the amendment was only to amend the fundamental right, so as to help the state legislatures in effectuating the policy of agrarian reforms. Now, we have to focus that agrarian reforms were extremely important, because after 1965, after that, around 2 decades is when the Green Revolution actually happened. So in the connection, it was the Shankari Prasad's case in which the validity of the First Amendment was upheld, and Sanjay Singh's case in which validity of the 17th Amendment Act had been upheld by the court had wrongly been decided. It was contended that the Parliament had no power to amend fundamental rights in Part 3. Now let's look further. In I.C. Golaknath and others versus State of Punjab, 1967, the constitutional validity of amendments related to property, namely First Amendment, Fourth Amendment, and 17th Amendment, were again challenged. And Supreme Court was asked to reconsider its earlier decision in Shankari Prasad and Sanjay Singh's case. It was contended that Parliament had no power to amend the fundamental rights. So the 11 judges participated in the decision, and they divided into 6:5. The majority now overruled the earlier 2 cases and held that fundamental rights were non-amendable through the constitutional amending process under Article 368. Now here I would like to point that we have noticed in the previous judgment that it was there was just one, I will just quickly go back to the slide and show that here we notice that it was a majority of 3:2 in Sajjan Singh's case. And in Golaknath, we noticed that it was 6:5. And again, in Kesavananda Bharti, we will see that once again, it's a wafer thin majority that has held the structure of the constitution, that has fought India from slipping into a totalitarian state. So let's look at the 24th Amendment of Constitution Act 1971. In order to nullify and supersede the judgment of Golaknath, to provide unlimited power to Parliament to amend any part of the Constitution, including fundamental rights, the 24th Amendment was enacted in 1971. The 24th Amendment expressly empowered the Parliament to amend any provisions of the Constitution, including those relating to fundamental rights, and further make Article 19 of Constitution inapplicable to an amendment of the Constitution under Article 368. Now, see the complexities that we might have been living in if that was the case still. So a new clause was added to Article 13, which said that nothing in this article shall apply to any amendment of this Constitution made under Article 368. Second was amendments were made to Article 368, which said the article was given a new marginal note, power of Parliament to amend the Constitution and procedure therefore. And the last was another amendment to the Article 368, now Article 368(2), made it obligatory rather than discretionary for the President to give his assent to any bill duly passed under the article. Now see, if this was the case, we would have a very authoritarian state that we would be living in. So next comes the 25th Amendment to the Constitution. This amendment, the provision Article 31, dealing with compensation for acquiring or acquisition of properties for public purposes, so that only the amount fixed by law need to be given, and this amount could not be challenged in the court on the ground that it was not adequate or in cash. And now we see that we are able to challenge in court if somebody feels that the amount paid to them in compensation is not adequate. So we are able to, in retrospect, able to figure out the latest developments and the times that we are living in. Further after, Article 31B of the Constitution, Article 31C was inserted, which provides for saving of laws, giving effect to certain directive principles in Part 4 against Articles 14 and Article 19. Now the 29th Constitutional Amendment, which inserted therein two Kerala Amendment Acts in furtherance of land reforms after entry 64, namely Kerala Land Reforms Amendment Act, which was entry 65, and entry 66 was again Kerala Land Reforms Amendment Act in 1971. So there were two amendment acts. Now let's look at the Kesavananda Bharti case versus State of Kerala. Okay. So the main question involved was the extent of amending power of the Parliament under Article 368 of the Constitution. This case, therefore, was also known as the fundamental right case and the basic structure theory case. In this case, the petitioners had challenged the validity of the Kerala Land Reforms Act. And it was also about the power of the Parliament. The two main issues in this case were the power of the Parliament to amend the Constitution. Was it unlimited? And the second was that the Parliament could alter, amend, abrogate any part of the Constitution, even to the extent of taking away all fundamental rights. But during the pendency of the petition, the Kerala Act was amended in 1971, and same was placed in the 9th schedule by the 29th Amendment Act. Petitioners were permitted to challenge the validity of 29th Amendment Act to the Constitution. The constitutional bench, comprising of 13 judges, and that is the biggest bench we ever had, unanimously upheld the constitutional validity of the 24th Amendment Act, and in doing so, overruled the prior decision of the Supreme Court in Golaknath's case. Now, as I mentioned earlier, it must be remembered that this was decided by a wafer-thin majority of 7:6. If the scales had toppled the other way, we would have been in a disastrous state and there would have been more and more cases challenging so. So according to them, the basic foundation of the basic features could easily be discernible from the preamble as well as from the whole scheme of the Constitution. For example, 3/4 supremacy of Constitution, 3/4 Republican and democratic form of government, 3/4 sovereignty of the country, 3/4 secular character of Constitution, 3/4 separation of powers between legislature, executive, and judiciary, 3/4 federal character of Constitution, 3/4 the dignity of the individual secured by various freedoms and basic rights in Part 3, and the mandate to build welfare state contained in Part 4, and 3/4 the unity, integrity of nation constitute parts of the basic structure of the Constitution. So this is the basic recipe for the basic structure of the Constitution. And we should remember the fact that the phrase basic structure itself cannot be found in the Constitution. It's not given anywhere. So it was based upon the discerning 13 judges at that time who figured out what would be the basic structure. The Supreme Court recognized this concept for the first time, of course, in the historic Kesavananda Bharti case. And it is just a little out of the topic thing I'm citing that one of my seniors had pointed was that the Kesavananda Bharti case had hundreds of cases which were cited. And they say that a chart was prepared which was citing constitutions of 71 countries, mind you. Next is we are going to talk about the Minerva Mills case of 1980. Here the power was given to the Parliament to amend, and it was not an unrestricted power. This power under Article 368 of Constitution gives a limited power to the Parliament. Parliament cannot go beyond this power to amend the basic structure of the Constitution itself. The basic structure doctrine as accepted in Kesavananda case is of utmost importance. The Section 4 of 42nd Amendment was held unconstitutional. Now let's not forget that when this case of Minerva Mill happened, it was a very crucial time. And this was the case which came right after emergency in India. So the political and social scenario was very difficult. And we are talking about thick textile mills and all that had come into existence, and they wanted nationalization of these. So the two main issues were whether Section 4 of Constitution's 42nd Amendment Act was constitutionally valid, and whether the clauses 4 and clauses 5 of Article 368 were constitutionally valid. So as we see that it was upheld that it was not valid, it was unconstitutional. And the law given under Article 31C provided for directive principles of state policy and had to operate to achieve its goal. And by no way it was supposed to destroy the fundamental rights, but they noticed that by this point, the fundamental rights were questionable and DPSP had superseded the fundamental rights. So let's look at the 42nd Amendment. This Amendment Act is also known as a mini constitution because of higher number of articles which were amended and newly inserted by it. Some important articles were 32A, 131A, 144A, 51A, 128A, and 257A. So it was established that the primacy of DPSP over fundamental rights, and words like secular and socialist were added to the Indian preamble. Now, a quick look at the 44th Amendment, which the major changes brought were the 42nd Amendment was repealed. Apart from them, right to property was declared as a legal right, not a fundamental anymore. So the power of Parliament in bringing many amendments to the Constitution with respect to 9th schedule was justiciable, except in 4th, 39th, 40th, 42nd, and 76th Amendment, where the Parliament placed some controversial laws, non-agrarian laws, into the schedule and tried to misuse and abuse its power in order to show its supremacy by making the Constitution text very weak one. And we should just going to conclude by saying if the majority of Supreme Court had held that Parliament could alter any part of the Constitution, India would most certainly be degenerated as an economy, as a democracy, and also in a totalitarian state where a one-party rule would have definitely been there. So I would wind up my presentation now and pass on the floor to my seniors, and I look forward to listening to them now.
Yes, ma'am. Prachi ma'am, you have well elaborated with the PPTs, and it was well PPT made by you, and you have elaborated all the amendments. So now we are handing to our one of the senior most advocate, Mr. SD Sanjay sir. Sir, over to you, sir. Sanjay sir. Sir, your mic is mute. Yeah.
Yeah. Good morning to all. My friend and colleague, Mr. Prachi Singh, Additional Solicitor General of India, Allahabad High Court, young advocate Prachi, Professor Rajesh, and the Dean of Parul University, and all my friends who are connected in this webinar. I greet you all for joining this session. A very important topic has been selected for today for discussion, and every student of law must be aware about all this, because perhaps in your lifetime and in your career, you may hardly get opportunity to go in detail on this subject in your practice, because this is a very serious constitutional matter dealing with the entire concept of our constitution and constitutional governance, rule of law. Now, Prachi has in very elaborate manner detailed and given the background of what has happened. And one quote she has made that our constitution is a living document. Friends, what is living? Human being is a living, plants, trees are living. So what happens with us? When a child comes out on this earth, gradually it is nurtured and it grows. Then it attains youth, come out young, then take the social responsibilities, and this is how it develops. Similarly, plants. Now, same is the position of law. She has very rightly said that what is the need of amendment? The need of amendment is our society is changing. What was not relevant 20 years back or 30 years back has become relevant now. Now, if we should still continue with the same set of law today, perhaps we may not be able to cope up with the situation and need of the society. Therefore, the legislature has kept this, that there can change in the law, and even there can change in the source of law, because source of law is our constitution. When we got the freedom, then the constitution framers prepared this codified document in the name of a constitution, which is the source of all laws, and all laws found their source in the constitution. But can the constitution remain a static document? No, it has also to be a very dynamic document. And as per the need of hour, because everything was not contemplated when the constitution framers gave the constitution to us. So they left the scope for changes in the constitution. Now, the law developed like a child. In the year 1951 to 1965, which Prachi has said, right from Sankari Prasad case, Sajjan Singh case, there were different views of the judges. Now, the thinking and perception of the judges also were different as per the need of the society. Thereafter, it changed. Now, what was said in those two judgments was that constitution is also like a law, regulation. Now, therefore, it was said that the parliament has the power to amend any part of the constitution. But this was not found favor when the Golaknath case came. And in Golaknath, the earlier judgments were reversed. And it was held that the parliament does not possess power to amend any provision of Part 3. Of course, the intention of judges were to secure the fundamental rights of the citizens. But then the law could not have stuck there only. There were different occasions when different amendments were made, like 24th Amendment. As per the political situation in our country, changes were made in law and changes were made in the constitution. So the most important case, which is the main case for discussion today, Kesavananda Bharti case, which is a document which will remain forever remembered in our country because of its contribution, because it is this judgment where 13 judges held the court, and out of 13, 9 recorded their opinions separately and propounded the doctrine of basic structure. What is basic structure? They could not define what is basic structure because it can never be defined. Because today something may be a basic structure, tomorrow may become stale, and something more will become basic structure. Therefore, the basic structure cannot be codified, but as per the need of hour, they tried to give their perception, and in their verdict, in the Kesavananda Bharti case, the court held what is basic structure. I will tell you, friends, that Chief Justice Sikri, he held in his judgment, he said that the basic structure may set to consist following features. First, supremacy of the constitution. The constitution is supreme. Then republican and democratic form of government. This is our ethos. The whole ethos of the constitution is that when India became independent, then it was said that we will have a democratic form of government, which is the best form of government. So the republican and democratic form of government is our ethos. Therefore, it can't be changed. We can't tomorrow shift to monarchy, aristocracy, or any other form of government. Nobody can change it. No ruler can change this. Now, secular character, because we are a country of diversity, and therefore the need was that we must have secular character. Then, since we have different states and there are separation of power between legislature, executive, and judiciary, all three organs are three pillars of democracy which function in their own area. And they are completely separated with each other, not encroaching upon the power of others. And then federal character, that our states have their own powers, and we are called unity in diversity. So our character is federal. Nobody can change it. Nobody can say that all the states must merge in the union. This will be a basic structure which can be judicially reviewed by the court. Then another set of two judges, Justice Shellett and Justice Grover, added in this list, saying that dignity of individual, then unity and integrity of the nation. Nobody can go against this. So this was the basic structure theory. Then Justice Jagmohan Reddy further held that the element of basic structure are indicated in the preamble and translated into various provisions of the Constitution. And he further added that sovereign, democratic republic, parliamentary democracy, the three organs of the state, certainly in his view constitute the basic structure. So it was based on the understanding and perception of this, our Constitution and its ethos. So the majority ruling, the court held that although the fundamental rights could be amended, which was not there in Golaknath. Now, they said that now even the fundamental rights can be amended, but those which constitute basic structure of the Constitution or basic features of the Constitution, that cannot be abridged, cannot be affected. The court said that the Parliament has vast power to amend the Constitution, but it draws the line by observing that certain part of the Constitution are so inherent and intrinsic to the Constitution that even Parliament cannot touch it. Now, the court held that 24th Constitutional Amendment was entirely valid, but it found that second part of 25th Constitutional Amendment to be ultra-virus. Now, therefore, friends, this judgment, and let me tell you that this was argued by one of the biggest legal luminary in the country, Nani Palkiwala. He was the main counsel. And then in the year 1975, there was an attempt to review the Kesavananda Bharti case. And let me inform that when this attempt was made in the Supreme Court, and the matter was listed, Mr. Palkiwala appeared opposing any attempt to review. And it is only because of his spellbound argument for 2 days that the judges were persuaded not to touch this doctrine of basic structure. And this is how it continued. Now, the process of amendment is now there under Article 368. My friend Prachi has elaborated it, but then I will only tell you that for the constitutional amendment, when a bill is passed, it has to be passed from both House of Parliament, and it must be passed with 2/3 majority present and voting, members present and voting. Now, in a case where the amendment affects the states, then it requires to be ratified by 1/2 of the state legislature. And thereafter only the president has to provide his assent for amendment to become effective. Now, major constitutional amendments have been dealt with by Prachi, but I will tell one thing, that Honorable Justice Y.V. Chandrachud, the father of the present Chief Justice D.Y. Chandrachud, Justice Y.V. Chandrachud, now he had dissented in his earlier judgment, but now after the basic structures doctrine having been accepted by the Supreme Court, he followed that in Indira Nehru Gandhi versus Raj Narayan case, in which Article 329A was under dispute with regard to the election of President, Vice President, and Prime Minister, Speaker beyond the scope of judiciary. So he said in his judgment that following basic structure, he listed 4 basic features which he considered to be unamendable, and that is sovereign democratic republic status, equality of status and opportunity to an individual, that is equality, Article 14, then secularism and freedom of conscience and religion, and the government of law and not of men, that is rule of law. We must have rule of law. Then came 42nd Amendment, and the famous case is Minerva Mills, which held that many things can be changed. Amendment can be made in the Constitution, but the power of amendment is limited, and this limited power itself is a basic structure. You cannot destroy the Constitution in the name of basic structure, or you cannot overrule the Constitution itself. Otherwise, it will go against the constitutional ethos. Therefore, the Minerva Mill case is another most important judgment for protecting our basic structure, and it held that the power to amend is not absolute power to destroy or repeal the Constitution. The Constitution has to survive, and therefore the power to amend is limited to that extent. Now then 44th Constitutional Amendment, then 52nd Constitutional Amendment. Now in 52nd Constitutional Amendment, very important changes were made, that in our democratic setup, we were finding that the elected members were changing side after being elected, which was giving rise to corruption for making government. Therefore, in order to strengthen our democracy, there was a need of hour to make constitutional amendment. An amendment was made wherein 10th schedule was added, that if an elected member change the side, then he will be disqualified. He will have to give up his membership in the House. He has to come again for his re-election. Then only he will become again the member of the House. So this was a very important step which found support from the judiciary, although the challenge was that it is affecting the right of an individual, fundamental right. But the court said no, in order to strengthen the judiciary, this is an important amendment, and 10th schedule also was upheld. In a judgment of Kiloto Holohan versus Gichelu and others. Then another very important judgment came on reservation. Now, when the government, on the basis of Mandal Commission report, came out with reservation on the basis of socially and economically backwardness in the country, then it was challenged in the case of Indira Sahni. And I think all of you must have read Indira Sahni judgment, wherein the Supreme Court upheld the power of reservation of the state, but capped it up to 50%, of course, with certain external circumstances where it can be enhanced. So this judgment was a milestone wherein the socially, economically backward persons were granted their due. Now, but the Supreme Court held that it can't be extended in promotion. Otherwise, it will affect the basic structure. But then again, in Nagaraj case, they upheld that even in promotion to scheduled caste, scheduled tribes, it can be extended, reservation can be extended. Therefore, there is a change in the views of the Supreme Court, even on the doctrine of basic structure, and that is one of the source of criticism. But before coming to that, I will also deal with that 93rd Amendment, by which the reservation in private institutions were not allowed, but the matter went to Supreme Court again, and in Ashok Kumar Thakur, the validity was upheld by the Supreme Court that this is a positive act by the state for granting equality among unequals, and therefore they said that this has to be preserved, and it upheld the amendment. So friends, these were certain examples where court upheld or interfered. Now comes the one of the most important case in the history of judiciary in our country, and that is National Judicial Appointment case. Friends, I have to say many things about this judgment and appointment of judiciary. Now, so far this amendment is concerned. Now, in the year 1993, in the second judge's case, the Supreme Court evolved its own procedure by which the judges of this country became the appointing authority. Although in the name of the president, but the primacy was of the judiciary in the collegium system, where in the appointment of High Court judges and Supreme Court judges, it is the view of the judges which has the primacy over the executive. Now, therefore, in order to bring transparency in appointment of judges, the Parliament brought an act wherein a 6-member commission was constituted for making appointment, and this 6-member included the Chief Justice of India, the 2 senior-most judges, the law minister, and the 2 eminent personalities of the country. But this was challenged on the ground that this is affecting the independence of judiciary, because there was a law minister and 2 independent persons. So if these 3 hold one view, then the judiciary cannot have majority. And this is how they held that this is directly affecting the independence of judiciary, and thereby it is affecting the basic structure of the constitution. And by this judgment, that parliamentary law was struck down on the ground of basic structure. That because of independence of judiciary and separation of powers. Thereafter, 103rd Amendment came, which was granting reservation to economically weaker sections. Now that is under challenge, and the challenge is still pending. So I don't want to make any further comment, but this was also a positive act on the part of the government to implement its policy to grant even reservation to economically weaker sections in the higher caste people. Now, friends, now the question is, from all these trends of these judgments, what follows? There are a lot of section of people which are also against the basic structure doctrine with various grounds, various reasons. Then some support the basic structure, some opposes it. So there are 2 lines of thinking. Like any case, in any debate, there are 2 sides. One side is for, one side is against. Similarly, so far the basic structure doctrine, which was propounded by the Supreme Court with a very laudable objective, but then finding that it does not have any parameter. It is not a codified law. Now, anything and anything, everything can said to be form part of basic structure at times. So basic structure cannot become an unruly horse in our country. Now, in the name of basic structure, or in the pretext that it is violating anything, any law or any amendment is violating the basic structure, that follows also separation of power, it can be said that basic structure is being impeached, and judiciary is whether justified in restricting the power of parliament to amend the constitution. Now, friends, democracy is the government of people, for the people and by the people. Now, the mandates of parliament on all issues concerning society will be left to the will of the people. This will have to be exercised by parliament. Now, I'm saying this is one section which is arguing. Now, the states have duly authorized to act on behalf of the people when the government is formed by the elected representatives. Then we people gave ourselves this constitution now and delegated our power to the parliament. So, in essence, parliament cannot usurp to destroy the constitution. This is one way. And what has been held by the Kesavananda, yes, that parliament cannot usurp all the power to repeal or even destroy or to affect the constitutional ethos and democratic ethos. But then the other side of the argument is that who is exercising the power to restrict this? That is the court of law, the judges of the Supreme Court. Now, it is said that they are not the elected people. They are not representing the will of the people. They are not accountable to the people. So this is the criticism against the doctrine of basic structure, that this cannot prevent the people, the will of the people. So this is one of the most important criticism, that the judiciary cannot restrict the legislative act of elected legislature. So another argument against this theory is that the component of basic structure doctrine, such as rule of law, secularism, federalism, which has been enunciated in a highly abstract manner, permitting varying and different interpretations. There is no exhaustive list of basic structure, and the court insists on dealing with on case-to-case basis, where on one hand, the judiciary has laid down the basic features are concepts so intrinsic and inherent to the constitution that they can't be altered. Yet, on the other hand, the court has not spelled out what will constitute the basic structure. With no predefined or set rights that ought to be protected, it may be said that somehow the judiciary has not laid down any set parameter while considering what rights are vitally important and need to be protected. Hence, this doctrine is still operating in the sphere of heaviness, and different views have led to varied interpretations. Like you have seen Indira Sahni case, wherein the court held that it can't be, reservation cannot extend to promotion. But then in another judgment, it said, yes, it has to be extended in Nagaraj case. So it is still in the arena where different interpretation of basic structure may come. Now, one such domain, we can see judiciary acting on its own whims and fancies is a matter of judicial appointment. The whole system of judges appointing the judges is a strong depiction of elitism, which runs contrary to the heart of constitution, the principles of equality, and also against democracy. The aspect of judicial appointment, judicial primacy in the appointment was never found in the constitution. If you read the constitution, you will never find that judiciary can appoint the judges. It is not there. However, by virtue of collegium system, they have done it. And therefore, while employing the doctrine of basic structure, they have struck down this. And it had denied the judicial accountability. Now, friends, we have seen that so far judicial appointment is concerned, a lot of talks have been going on for appointment, for constitution of a commission across the country for judicial appointment, like All India Judicial Service, where merit is the criteria, because you all are young and you will be coming out for practice. You may be aspiring to become judges, the High Court and Supreme Court, but the system prevailing does not permit any meritorious to be appointed. And therefore, you have to come out, you have to deliberate, debate, and you have to send the message to the government that we need a constitution of this. When we were studying in the college, and from that days, we used to discuss in Delhi University that National Judicial Service is coming, but we have crossed 2021, it has not come. But I still have not lost hope that young people like you will bring this system so that judges' appointment are not based on whims and fancies of the judges, but on merit. And therefore, I appeal to you to come forward, deliberate for this in our country. And I thank you, Parul University, for giving me this opportunity for the third time to speak my views. And sorry for taking a lot of time. Thank you. Thank you.
Thank you, sir. SD Sanjay, sir, you have elaborated in a very well way, and lots of judgment you have incorporated, and in a very dynamic way, you have explained each aspect in a very detailed manner. So now I am handing to one of the topmost advocate from Allahabad High Court, who is the senior designated advocate as well as additional Solicitor General of India. So now this session I am handing to Mr. Prachi Pratap Singh. Over to you, sir. Sir, your mic is off.
Yeah. Thank you, Rajesh ji, for inviting me to this August webinar. My respect to SD Sanjay ji, Miss Prachi Pratap, the Dean Faculty of Art, Law, Parul University. I'm very happy to be here with you because Parul University is in Vadodara, and I was a student up to ninth class in Vadodara.
Okay.
While I was a student in Vadodara, for the first time in class 9th, I heard about the Constitution of India. What is Constitution? The basic feature of the Constitution which was taught to us, was that it is a rigid Constitution, as well as it is a flexible Constitution. So, as Prachi ma'am has rightly said, that it is a living document, and that is why it has been this Constitution up till now, it has been amended for 105 times, and in all these amendments have been brought. They are brought not by I should say that not on whims, rather it was the requirement of the society, and for the upliftment and the of the democratic setup of the constitution and of the country. So so far as so much has been said about this, Prachi ma'am has very elaborately narrated everything from 1951 to up to the 105th Amendment, and the remaining part has been completely and very nicely deliberated by Sri Sanjay. So there is nothing remains to be said, but still I will make some very small submission. The Constitution, Article 13 of the Constitution provides that the laws inconsistent with or in derogation of the fundamental rights are void, and therefore there are we have been provided, the Constitution has provided Article 368. The Article 368 has been very nicely dealt by Ms. Prachi, but I will again like to read it for the benefit of all these, particularly the students. The Article 368 provides that notwithstanding anything in the Constitution, Parliament may, in exercise of constitutional power, amend by way of addition, variation, or repeal any provision of the Constitution in accordance with the procedure laid down by in its article, in this article. So there are three types of amendments in the Constitution, for the Constitution. The first is simple majority. By way of simple majority, the amendment can be carried out. And the second and third type of amendments are to be amended by the majority, two-third majority of the parliament voting at the time of present in the voting. So this second and third type of amendment, and third, there is one more requirement, as has been already explained by Sanjay, that when it is involved, it was the states, then it will require the ratification by the state legislature also. So there are three kinds of amendments. So basically from right from 1951 till date, the main the basic structure, what is the requirement of amendment? It should not affect the basic structure of the Constitution. And for that, in Kesavananda Bharti case, in para 1332, if we will look into it, it says that what are the conditions, there are conditions laid down. There are 12 conditions laid down for the amendment. Number one is the supremacy of the Constitution, the sovereignty of India, the democratic way of life, the republican form of government, the guarantee of basic human rights referred to in the preamble and elaborated as fundamental rights in Part 3 of the Constitution. 7, a secular state. 8, a free and independent judiciary. The dual structure of the union and state. The balance between the legislature, the executive, and the judiciary. The 11, parliamentary form of government and distinct from the presidential form of government. The amenability of the Constitution as per basic scheme of Article 368. So these are the 12 guiding principles which have been laid down by the Honorable Supreme Court, and there is no dispute that till date there is no change in these guidelines. Therefore, to sum up, I would say that since we are among this, we are talking to the students, the young generation, which is will shortly join us in our profession. Maybe with some maybe with our friend as advocate. Some of them may join as a judicial officer, or some in similar situation positions. Therefore, it is as said by Mr. Sanjay, that it is for them to ensure that the democracy the setup of the constitution, the basic structure of the constitution is secured and is saved by them in future also. So far as the NJAC judgment is concerned, and my my views may be otherwise also, but my submission would be that in any case, the appointment of judges should not be in the hands of the judges themselves, because nowhere in the world, this system is going on. This has to go. Otherwise, as we are every day facing problem in the system, and therefore we have to evolve some system under the constitution, how to get away of this situation. And I think the coming generation will have better future, and they will lead us. Now they will lead us, because the Prime Minister is every day saying that it is the time that the youth has to come forward, and definitely, like the Prachi ma'am is there, other young boys are there, girls are there, they are hearing me, and so I think that so for my views are, yes, for today it is sufficient, and nothing more is required. After hearing Mr. Sanjay so elaborately, then nothing remains to be added. Therefore, I will stop here, and thank you all for inviting me in this wonderful session, hearing Ms. Prachi and Sanjay who are very would say very illustrative speech, and quite learning for me also. Thank you all.
Sir, it was very fantastic session, Mr. Sasi Prakash Singh, sir. You have elaborated the major content, that 93rd Amendment and the judiciary part. You have elaborated in a very well way. We are very much obliged to you, sir, for this your participation in this event. Now, sir, we have certain questions from the students on which they have put in to me. Sir, we have one judgment of IR Kolo. That is, it has been elaborated that judiciary has a power to interpret if any law which is made by the legislature. So my question is that whether the amendment can be applicable in this particular aspect, whether the judicial review has any aspect with correlated with the amendment. Over to Sanjay, sir. Sir, it is mute.
Sorry, I could not hear.
Sir, the question
there was
is
some disturbance, so I could not.
Yeah, so the question is, there was a one judgment of IR Kolo where the Honorable Supreme Court said that judiciary has a power to review if any law which is made by the legislature. Now, my question is that, okay, judiciary has a power. Okay. Now, is there any connection with the amendment part in this case? Hello, sir. It is muted, sir.
So far as judicial review of any law is concerned, now there the question of basic structure will not come. Now the courts have power of judicial review of any law, and if it founds that law is contrary to the provisions of the Constitution, then it can easily interfere and strike it down. Now the question of basic structure will come only when it is the amendment in the Constitution. So what the question means about in this judgment, that whether it is judicial review power of the court of a law or Constitution. Now that is not clear to me. Now, if it is of the law, then the court has the power of judicial review. There is no difficulty about that.
Okay, sir. Very well elaborated, sir. We have another question from one student. This question to Mr. Sasi Prakash Singh, sir. Sir, you have elaborated that judiciary, if judiciary has a control, then it is very much demarcatic, and the judges cannot be appointed in a well way. Now, sir, as per the 93rd Amendment, when after this, when this amendment came, and this judges case, second judges, first judges and second judges case, sir, is there any provision in our law that if suppose after this amendment we have a chief justice, we have three senior most judges of the Supreme Court, I think these are the three criteria right now for the selection of the judges, correct? So the question of the student is that, is there any other legal authorities involved in these types of selections? Hello. Sir, it is not, it is muted, sir. Hello.
No legal authority is involved in this, except that the government of India, Prime Minister and President of India is required to review the review and the therefore in the review he may refuse, and that is what happening on long pending case. Appointment of judges are going on because of this system. Therefore, otherwise there is no legal authority except the collegium and the proposal and the recommendation sent by the High Court and the Supreme Court for the to the government, and the government has to review it. Either they then don't agree, they keep it pending. That is all. So
thank you, sir. Sir, one more question from one of the students that, sir, already we have a Mandal Commission case where the Supreme Court had laid down the 50% reservation. Now, sir, the question is, just a minute. Now, the question is, sir, that right now after 103rd Amendment, 10% reservation for this for extra for this reservation for this. I am just forgetting, sir. This question is from one of the student that that 10% reservation in the 103rd Amendment. So, sir, is it you are not thinking that it is crossing the 50% reservation criteria? Suppose 10% special category people from from the general categories were allowed, then what can be done, sir, in this particular case?
Question to whom?
Mm-hmm. 103rd Amendment, sir, I'm talking about.
This is a question to me. Once 103rd Amendment provides for
sir.
Maximum of 10% reservation.
Yes, sir. Yes, sir.
Economically weaker sections.
Economically weaker, yes, sir.
Yeah, of citizens of classes other than the class mentioned in class 4 and 5 of
Yes,
Article 15, that is classes other than socially and educationally backward classes of citizens of or the scheduled class. This is a debatable question. It will be within and within the 50% quota or not. This is
so, sir, my question is that whether suppose 10% reservation has been given, okay.
Yeah,
now my question is that whether IR Sani will be applicable in the selection process if already 10% has been already given to them. Is it applicable? That is my question.
To my knowledge, probably this is also under consideration before the Supreme Court.
Yes, sir.
Therefore, it is too early to say at this stage. But in my opinion,
yes, sir,
it should not. It should not.
Okay. Okay,
because it is within 50. It is for the within 50% of that quota, which already is for them. Therefore,
Okay.
it will not cross the limit which has been fixed by the Indira Sahni case.
Okay, sir. Thank you, sir. Thank you. Sanjay, sir, we have one more question. Sir, if suppose any law which is passed, if it is amended, there are three steps. Okay, first is the simple majority, second is by two-thirds of the majority, third is 50% of the state says. But if suppose, sir, if a bill is being passed and it is presented to the president and president disapprove, so in how many days again it can be presented before the parliament or before the president? Hello, Sanjay sir, over to you.
Yes. Sorry.
Sir, my question is that if
Hmm.
there are three categories of the amendment. First is simple majority, second is by two-thirds of the majority and assent by all the, then third is the by 50% of the state. Now my question is that if suppose a bill is passed and it is given to the president for the assent and
Yes.
president has rejected in any problem in that particular bill, so in how many days again it can be represented to the president?
In how many days it has to be represented to the president?
Yes, sir.
Now, in my view, so far time is concerned, because if a bill has not been assented to, it will not come into force. Now, then it will come back to the legislature. Now, if they want again to send it to the president, then to my memory, no time is fixed as such for this purpose. It can send back after, or they can constitute a committee, because you see, when the assent has not been given by the president, then there must be certain reason will be recorded to that. Now,
Yes,
if
sir.
that reason is changed or it is rectified by the legislature, or if they appoint a committee, that they will consider that reason. And if any reason which has been pointed out for not granting assent, normally president grant assent to any law bill which has been passed by both the houses.
Yes,
But
sir.
if for any reason he reserves his assent, then that will be brought to the notice. And then once it is removed, it can again be sent back. So to my
Yes, sir.
memory, of course, I have not checked that provision, but then
Yes,
it
sir.
can
Yes,
be
sir.
referred, because this is a question of provision, whether the
Yes, sir.
provision
Yes, sir.
fixed number of days or not.
Yeah, sir. Actually, one student have asked, so that's why I put it this question. Sir,
Yes,
now we have ending this all the questions, sir. So since the starting, Prachi madam has elaborated with the various case law from this Sajjan Singh, then Shankari Prasad, and then Golaknath, and then Kesavananda Bharti, and thereafter Sanjay sir has taken the lead, and he has elaborated about all the cases, particularly of the Kesavananda Bharti case. He has elaborated in a very well way. And thereafter, he has also elaborated about the Minerva mill. And then thereafter, he went to this Raj Narayan case. Sir, I have one more question, Sanjay sir. Sir, because if something is put in the 9th schedule, Indira Gandhi has did that she is putting everything in the 9th schedule. And 9th schedule says that you cannot touch in the 9th schedule if anything is put by the parliament. Sir, what is your view in this particular case, that why she was putting everything in the 9th schedule?
You see, when the government wants power, excessive power, and it wants that any of its policy, like you see, if the intention is good, like agrarian reforms, so if that was put, now again the question of basic structure will come, whether you want to do something which has the effect of destroying the constitution, or something you want completely go out to take it out of the pale of challenge. Now that can't be done. Even there also the basic structure will come into the way.
Yes,
Otherwise,
true, sir.
it will have the effect of destroying the constitution, or
Yes, sir.
completely
Yes, sir.
changing or repealing the constitution. Even
Yes,
by
sir.
putting by putting it in the 9th schedule means you are to take it out of the pale of the challenge. So something if you want to impose certain policy by bringing it in the 9th schedule, if again it is against the spirit and ethos of our constitution, then it can be challenged on the ground of basic structure.
True, sir. True, sir. So after that, Sanjay sir has elaborated on the 93rd amendment and all the judges' cases he has referred, first judges' case, second judges' cases. And thereafter, we have handed to one of the topmost advocate, Mr. Singh. He has elaborated especially on the para number 13, subclause 32 of Kesavananda Bharti case, which has been given a very impact on this.
1332.
1332, sir. Sorry, sir. I have written wrongly, sir. So he has elaborated about the basic aspect, that is the supremacy, sovereignty, republic, secular, dual structure, and all. There are total 12 points he has elaborated. So it was a very fantastic session by all of you, all three, sir. And we are very much thankful that it was a really very fantastic session by all of the three. So on this behalf, I on the behalf of Parul Institute of Law, Parul University, I thankful to all of three dignitaries, and we will also think that when this pandemic will be over, we will invite you physically on this at this Parul Institute of Law, Parul University. So on this behalf and this note, I am closing this session. I am thankful to Jiten Kubani sir, who has given the live coverage of this on the Facebook, and thankful to all of the viewers who has watched this and elaborated the good time on this platform. So thank you to all. Thank you, Sanjay sir. Pranam sir. Thank you, Sasi sir. Pranam. And thank you, Prachi ma'am. Pranam. So we are closing this session. Thanks a lot, sir. Thanks a lot for your kindness, sir. Thanks a lot, sir.